everyone, my name is Julia Fleming, and today I will be talking about best practices when it comes to terminating employees and how we can really create a roadmap from discipline to departure throughout the employment relationship that really sets a solid foundation to support a termination later down the line and set ourselves up to reduce the risk of liability. So starting pre-termination, we really want to start the process for termination well in advance of when the actual termination will be needed. How can we do this? Well, throughout the employment relationship, it's best to document any issues that might come up from hire to discipline throughout the employment relationship so that if a disciplinary action or termination is needed later down the line, we have documentation to support that decision. So this could be anything from performance reviews that inform the employee their performance is not meeting expectations, written warnings when it comes to policy violations, really just documenting anything along the line that might later support a termination if a employee were to challenge that termination as based on unlawful grounds. So in thinking in advance, we want to take a look at what documentation we have to support the termination. If we don't think there's sufficient documentation, consider whether we can take a little extra time to issue a written warning to the employee, put them on notice of any performance improvement that's needed to avoid a termination. In thinking through all aspects of the termination, consider some things such as what company property the employee might have in their possession, if they have access to any confidential information that might be at risk if they're terminated. Is this a remote worker such that there might be special considerations in that way? Or does something tell you this employee might be likely to bring claims if they're terminated? So lots of things to really think through in advance of moving forward with the termination. Along those same lines, we want to focus on the importance of a paper trail, like I mentioned, throughout the employment relationship. So this is just making sure we're keeping a written record of everything in case claims are made later down the line. So this could include your performance reviews and evaluations, any disciplinary records, if an investigation is conducted, those documents. So really just taking a step back to consider if this ended up in court, what would a judge and jury see? Would they see a termination that was supported by performance reviews that showed insufficient performance? Really just any documentation to support business decisions. So if one employee is promoted over another, is there documentation to support this decision? If one employee is issued a written warning in a situation and another is terminated, do we have documents that, from objective perspective, show that reasoning? Now, the documentation doesn't need to be all formal. It can be handwritten notes if you have a meeting with an employee and discuss some discipline with them. Emails will suffice as well. And to make sure we're preserving this in case it's needed in the future, go ahead and store that in the employee's personnel file. Still pre-termination, consider whether it could be helpful in the future to have done a more comprehensive fact-finding investigation, like my colleague Hannah was discussing. Pre-termination, should we conduct an investigation? Be sure to check any employment agreements or handbook policies to see what, if anything, the company promises regarding separation. Do you promise a notice period in the event of layoffs or to pay out PTO or paid sick leave? And generally, it'll be best practice to treat employees in similar circumstances the same way. So if one employee is laid off and given severance, we want to treat other similarly situated employees the same. Also, pre-termination, give some thought to the reason for termination and being able to articulate this. This is important for a couple reasons, first of which the employee does have the right to request the reason for termination in writing. And also, just when discussing the termination with the employee, you'll obviously have questions and they'll want to know the reason. So, giving this thought in advance will help you be prepared and make sure we're focusing on lawful reasons for the termination. Is the termination related to performance issues, policy violations? Making sure the termination in no way is directly or indirectly related to a protected characteristic or for engaging in protected activity, as that will be unlawful discrimination and retaliation. And so if there's situations in which a termination overlaps with protected activity or the timing sort of coincides with an anticipated termination, we'll need to be extra cautious in dealing with those situations just to ensure that the termination is not based on the protected activity. If, for example, you anticipate terminating an employee for performance issues, and then she informs you that she is pregnant, we'll need to deal with this with a little extra caution to make sure we have that documentation supporting the reason for the termination. Another example, if an employee is out on paid family and medical leave and you plan to eliminate their position, therefore resulting in their termination, do we have objective business documentation that shows why this position was no longer needed and therefore is being eliminated? Now, getting to the actual termination. Hopefully, we've planned out everything in advance and thought through any special considerations. We want to make sure we're handling the termination professionally and with respect to the employee. So, how can we do this? It's best to really set up a one-on-one meeting with the employee to discuss the termination with them. At this meeting, you might consider presenting them with a letter that states the effective date of discharge, any next steps when it comes to returning company property, their benefits continuation. If the employee is being provided with severance and a separation agreement, this meeting is a good opportunity to give those to the employee. Similarly, if they've previously signed any obligations that will continue post-employment, like a non-compete or protection of confidential information, we can give the employee copies of these agreements at this meeting to remind them of these. If we think an employee might not take the termination well or there might be a certain issue with the meeting, consider whether it might be beneficial to have a witness present to this meeting to really serve as a third-party observer to what occurs. And then being prepared to collect any company property the employee might have. Do they have physical files at home that will need to be collected? And communicating with IT in advance also so that we're ready to cut off access to their email and company server. If there's no time to plan ahead for a termination, if there's an incident that provokes an immediately terminable offense, it's best to really sort of have a general procedure set up to address an immediate termination. This could again look to items we'll need to collect from the employee, as well as having a general procedure for IT to again cut off access to their email, company server. And in these situations where a termination might be immediately necessary, there might have been an incident or some sort of accident. It might be even more important in these situations to document what occurred. Were there any witnesses? And should we take witness statements? Thinking about presenting an employee with severance, it's important to keep in mind the purpose of severance. So severance is giving employees something more than they're already entitled to serve as consideration for their release of claims they might have against the company. So severance cannot merely be the employee's final paycheck, as they've already worked those hours and are already entitled to those wages. So it usually takes the form of an extra monetary bonus, keeping the company property or company stock, for example. Some special considerations to keep in mind when it comes to separation agreements. Employees that are 40 years old or older will be protected by the Age Discrimination and Employment Act, which applies to companies with 20 or more employees. In these situations, for the employee to release any age discrimination claims they might have, there's some special requirements that will need to be followed, one of which is providing the employee with a 21-day consideration period within which they are given the opportunity to consider whether they sign this agreement and therefore release those claims. Another requirement is a 7-day revocation period. So this means that even after the employee has signed the agreement, they're given 7 days to revoke their signature and retain the right to bring these claims. In recent years, Washington also enacted its Silence No More Act, which applies to what sort of conduct an employer can prevent an employee from discussing or disclosing. Similarly, the NLRB in 2023 issued its McLaren-McComb decision, which will also directly impact separation agreements, and in particular, the reach of confidentiality and non-disparagement provisions. So given these updates in recent years, make sure we're not providing employees with an old copy of a separation agreement, but ensuring that legal counsel has reviewed these agreements to make sure they are still valid and enforceable. Separation agreements can be tailored to fit the situation and the employee at hand. So if they have obligations that will continue post-employment, like a non-compete, non-solicitation, we can incorporate those into a separation agreement. If this employee has any specific company property we need to collect, we can condition payment of the severance on return of that property. You might consider offering a neutral employment reference as well, which provides that you will confirm the dates of employment and positions held. Now, post-termination, keep in mind if the company has promised anything regarding separation. Do you promise that payout of PTO or an exit interview? For companies covered by COBRA, you'll need to notify your plan administrator, who will then send out the required notices to the employee. In Washington, the employee's final paycheck must be received on or before the next regularly scheduled payday, so that's usually not an issue. And then keeping in mind what continuing obligations the employee is bound by. For obligations that apply to the employer, like my colleague Haley discussed earlier, employees do have that right to request the reason for termination in writing. If they request this, the employer must provide the effective date of discharge, as well as state whether there was a reason for termination, and if so, what that reason was. They also have the right to request their personnel file, and they retain this right for 3 years post-separation. And keeping in mind that if an employee is requesting the reason for termination in writing, if they're requesting a copy of their personnel file, this might sort of raise some red flags to the company that the employee might be thinking they're entitled to bring claims of some sort. So in this event, make sure we have legal counsel on hand to respond quickly. If we have any mediation or arbitration agreements in place, review those to see what procedures might be required. And then on the company's side as well, keep in mind whether the company might have any claims against the former employee. If they went to work for a competitor, for example, and you believe they might be misappropriating trade secrets, or if you believe they've solicited employees or customers in violation of a non-solicitation agreement.